disclosure here that we could do this and not get full funding back from FEMA for this, or only get a portion of it. But our mission here is to have the contractor go in, chip up and remove from the debris sites that were identified during the storm, and take that debris for disposal.
Who wrote that contract? Is that FEMA?
These are base, but they're also reviewed by attorneys that have specifics in federal. Yeah, so we have the base agreement. So that's a FEMA standard kind of under FEMA contracts here. So we have attorneys that specialize in the area look at it, and then the rest of it is referring back to the actual bid document. And then all those check boxes you see in the bid are all federal requirements, procedures we have to follow, and things you have to disclose. So we looked at it to the best of our ability and checked all the boxes that we're aware of, but at the end of the day, it's I guess the way I explain it, there's more reasons they could say you didn't meet something than you did, but I think we're on target the best we can to get reimbursement.
Mr. Chair, if I may, who has oversight of that job process itself? If we award this contract, then who has oversight that they're doing what they contractually said they would do?
Well, it's the county at the end of the day. We'll have monitors at the site that when they do the measurements, we'll have to have somebody there certifying those measurements.
That's my question. Who is that somebody? Is that county road or is that?
No, we'll have to hire a consultant to go do the measurements. Usually there are engineering companies that send the field inspector out, and so when they're processing during the day, the chipping's a bit new for us because we're used to dealing with volumes. When you put something in a truck or something, ship it, and chipping loose volume like that is something different. So we have conversation with the contractor on how they've handled that in the past, and then an inspector from an engineering company. They're not usually engineers; they're field inspectors who go out and verify the quantities. Shipping out vehicles is much easier because you can load it in the truck and measure it pretty easy here. So those are the two measurements: the shipping portion of it, and then the hauling portion. So, basically, we're looking at this figure. We're looking to stop. I mean, unless it's just a little bit over. That pre-measurement number on the loose debris is an estimate. So,
The reason I ask is because at one Kohler Township meetings, they discussed one of the tree removal companies that had chipped, and they had cleaned it up, but the township supervisor was one that was actually going out there and checking. When they reviewed this, it wasn't clear to me who would have oversight.
yeah, I mean, we could send a staff person. I'm looking to work with an engineering company to send somebody else. I mean, it could be the road commission too. I haven't talked to them recently on that. They would have somebody skilled in that area to do the measurement. So.
Thank you.
When a forester appraises your property, how much he's going to get off of it, you know how risky that is. Anyways, this guy is coming from Shawnee, Kansas. So that's a long ways to take the debris.
Yeah, it's not going back to Kansas.
What are they going to do? They're going to sell it to.
Go to the area. Some of it will go to Grayling.
Yeah, really.
Some of it will be distributed other places.
The particle board manufactured down there.
Yeah, and those are all things we when I say final confirmation in here, that's what we're trying to review to make sure we understand the whole process of where that's going, and FEMA doesn't have any particular issues with how we're approaching that.
The alternative is just to leave it there? Seems that to me.
Like it's been
Yeah,
done in the
we
past
did.
with sawdust?
Yeah, this bid amount is to move it off the sites. We have, our second number here was to grade it on site, which was a little bit less, but not enough not to move it out. So if for some reason FEMA comes back and has an issue with moving it off site, then we would reevaluate whether it was graded on site. That could be a possibility at the end of the day. But when that happens, then there's other potential review problems with the site itself as far as environmental reviews or other things. So there's, a lot of red tape, as you can see, 100 plus to try to work through there. Best case is we get, 320,000 or a better part of that back. The worst case is we don't, so we spend it. So it's, I know Emmett has their numbers in. They moved right after the storm and processed it. We're processing it according to what the federal FEMA guidelines are. This is exactly the way they tell us to do that, and we'll see where we all land there. So I know they haven't got anything back for that part of it.
We're working without paychecks right now, so probably won't be,
Yeah. Can't ask the FEMA person right now because they're out right now. So we send it to their email and keep moving forward.
So this is a product that's in the Gilner pit, the Myers pit, the Glancy pit, which is private Levering Road, Indian Trail Road, Woodrose Road, and Gravel Pit Road off of Rondo. That's by the expressway.
Yeah.
68,000 cubic yards plus.
Mr. Chair, I'll make the motion.
Thank you, Rich. Support.
I'll support.
Thank you, Jeff Olson. Support.
If we can't find somebody, Commissioner Warfield said he'll go venture. We'll get back in the day there.
I haven't forgotten how to calculate cubic yards.
Did you get that down, Madam Clerk? Okay.
Chairman, I have a question before we vote on it. Will you have to move money out of the fund balance to pay for this stuff, or where are you gonna get the money to pay for this?
It's not really moving out. I mean, we have enough in our accounts to pay for
Cover
it.
it.
Yeah, I mean, at the end of the day, if we don't get reimbursed, yeah, it'll obviously show up on our bottom line there. So it's, if we don't have that overage over it, it could potentially in our 26 audit showed up and use some fund balance on it.
Okay.
Madam Clerk?
Commissioner Warfield.
Yes.
Commissioner Wallace.
Yes.
Commissioner Claremont.
yes.
Commissioner Eustace.
Yes.
Commissioner Newman.
Yes.
Commissioner Ostman.
Yes.
Commissioner Sangster.
Yes.
Thank you, Board. That's carried 7-0. With Steve Warfield estimating the amounts in each pile.
I think I still remember how to do that, sir.
I bet you
It's all in
do.
cubic
I bet you
volume.
do. Anyways, we're down to 13E, the matter that was moved, the minutes of the last emergency meeting that was called
Yes, sir, I do.
when I was incompetent.
Believe incompetent would be the right word, sir. Incapacitated temporarily, but we
Yeah.
understand you're back and ready to keep fighting. and
Yeah.
That's a wonderful piece.
Rechain, retrain.
Good. Yes, it's just a observation and a correction to the minutes. But first and foremost, I would like to acknowledge our clerk and thank her for the detail that she put into it. Within one paragraph, she managed to capture exactly what I hoped that she would in describing what we're gonna discuss next under board member comments. However, the word stewardship was misspelled on page 7, but if Madam Clerk would correct the scrivener's error, I think the rest of it's very concise. And again, Karen, thank you for taking the time to do that. You clearly recognize it's an important issue to the community, and you're in one paragraph, you managed to condense exactly where I'd like to see this go. So, thank you for that.
You're welcome.
Anything else?
No.
We have a motion to approve it, then?
Madam Clerk, do we need a motion to change this? Okay, then I would make the motion that
Thank
we
you, Steve.
revise one spelling error in a perfectly written paragraph.
Thank you. Thank you, Rich. Moved and supported. Madam Clerk?
Commissioner Ostman,
Yes.
Commissioner Newman,
Yes.
Commissioner Eustace,
Yes.
Commissioner Claremont,
Yes.
Commissioner Wallace,
Yes.
Commissioner Sangster,
Yes.
Commissioner Warfield.
Yes.
Thank you, that's also covered, 7-0. Board matters for discussion, 238.
Place in the packet, some information for the board to review. First on page 238 is a resolution affirming natural resource stewardship as a foundation principle for the vision of the master plan. Just to start off that conversation, again, we talked earlier, the planning commission is working on the master plan rewrite. As part of that, in the sections of the master plan, there's chapters that cover environmental information. And talking with staff and legal counsel on this, I believe there will be an opportunity. I don't believe there's any issue if the board approves a resolution like this. As far as the way it looks like in the master plan, that will be developed as the process kind of moves forward. One thing that we're looking at the state level right now is the Public Service Commission's process to look at renewables is happening right now. I don't know the number off the top of my head. Catherine might have a better number of how many are going through the state PSC review.
There's 4 or 5 right now.
So what we're doing is monitoring that process, and as part of that, there's a process for getting information for the communities, and what allows us right now, because we're in the stages of developing not only our master plan but language, is to look at that process the PSC is doing, and then identify what information will be valuable for us to place in our master plan. So I think this is a kind of the foundation of stating that's what we're looking at moving forward, and when we understand that process, we can insert that information in our master plan. So looking forward, depending on how we get through the process and the planning commission reviews, it's quite possible we could have a local ordinance and then statements in our master plan that allow us to give comment to the PSC through the master plan itself. And so that's what we're looking at, and believe that's the way that will materialize. So if a company does go through PSC and we get a chance to make that comment period, that we can use that as the base foundation. And I'll turn it over to Commissioner Warfield.
I guess I would have one question as to your statement you just made. Are you suggesting that our planning commission will go ahead and go through their typical findings on one of these state-sanctioned projects so that we can follow the same procedure we would be following
I think that's what
prior to having our authority taken away from us?
Yeah, that's what I'm trying to learn right now, is what that looks like. As Catherine's indicated, there's several in motion right now, so we can monitor that process, and we'll know what it is. So I believe that's the way that will look, although the master plan is not a ordinance document. If the PSC is looking, what's the foundation of why a community is making a recommendation, and that will allow findings to be made out of that document. So it may end up being, in our environmental chapter, there may be another section or a completely different chapter that states on renewables. This is materializing as we work on this document right now, and has not been something that existed in the past. So I think that this resolution kind of sets that up, that, you know, that's important, and, you know, obviously as it's developed, we have that, so. Well, Catherine, you want to add anything else? Or?
Yes, under the current order, the MPSC order on how they will review projects, it's much more robust than what you can have under a CREO. They will consider you must provide alternate sites, they will consider impact on farmland, they will consider impact on natural resources. How that will actually be applied is as Jeff stated, unknown, right? So if in fact, whatever direction the county decides to go, if a project was to go directly to the MPSC, not only would you have the right for intervention in the case, right? But you would come in intervening with all your proofs essentially, like here's our master plan that shows this, here's our, you know, whether we have an ordinance or whether we just default to the MPSC, that will be determined. But it's a much broader scope of review. Now, as you recall, that implementation order, the MPSC, is under litigation, all right?
Yes.
70-plus municipalities have challenged that implementation. Oral argument on that case is now been scheduled for April 15th. My law partner wrote an amicus brief representing Michigan Townships Association. He will be watching that, whether he'll be in Detroit in person, whether he'll be on Zoom. So we will have information and how that oral argument goes, and then, you know, I'm not sure how long the decision will take. So yes, in theory, we know under Public Act 233 that the MPSC has a much broader scope of review than we had under a CREO, okay? But we'll see if that gets modified at all by this court case.
So does that in your mind, ma'am, does that in your mind satisfy the question that I've had, which is why would they not want to go to the state? Because up until just today, it had been one Wolverine Power that had gone to the state, but it sounds like we're now recognizing that going to the state is actually more closely monitored than what we would under our old CREO that we eliminated?
Well,
Or the moratorium?
so generally anecdotally only, applicants, power companies, whoever it is, would prefer to go through local review because it's faster and quicker, okay? The state has to act within 1 year. However, the amount of information that they have to submit for a state application is much more extensive, okay? In terms of reports, in terms of analysis. For instance, one thing I know is they have to have their preferred site, they have to have an alternate site, and they have to be able to justify why they went with the preferred site. So there's a lot more legwork for the applicants at the MPSC. However, when a company gets to a place where they've identified land, they've leased it, they've bought it, whatever it is, they've secured an interconnection to the grid, to the MISO queue, they are often pushed backed into a corner where they either have to go to the MPSC or they might lose the project, essentially. So you are seeing, like, probably over the last 6 months, there's been three, now there's 4 or 5. My little partner just did one last night down by Hillsdale, where the company isn't getting what they're wanting, so they're like, well, that's it, we're going to the MPSC. Different companies are more aggressive than others. Some will go directly to the MPSC and will not waste their time on the local municipality. So there's a lot of factors at play, and it's a very fluid environment at this moment.
And correct me, I want to make sure I understand correctly that with the moratorium on a CREO, it leaves them no opportunity but to go to the state.
Right now, there's no
And
opportunity.
then the state's requirements may be more onerous than even what we had as a county?
Yes.
Okay, thank you.
So while you're in a holding pattern,
Yep.
that's the option, right?
Thank you for
Mhm.
clarification.
So that CREO was, that renewable ordinance, that really wasn't equal to the state.
No, because that's kind of the hard part to understand is that CREO says you can only consider these 5 things. The state says, the state Public Act 233 says these are the things you consider, but the MPSC, when they decide how they're going to implement that law, has a very broad list of things they will consider, all right? Our firm consulted with the MPSC on what they need to look at in site plans, what they need to look at in decommissioning. So as people have actually done this, they asked for our input and they broadened the amount of information they are gonna ask for. Now, that whole regulatory scheme established by the MPSC is under challenge. And the oral argument will be April 15th.
But they can still approve though?
Can they still approve? Yeah, yes, right now they can. We'll find out if that changes after oral argument.
So they're looking for the courts to set the regulation.
Well, the MPSC feels good about what they did, 70-plus municipalities challenged them. And one of the issues, and I don't wanna belabor this, but one of the most important issues is, can the CREO be more than state law says it can be? So we've always understood it, no. Your CREO was exactly what the state law said it could be. That's our interpretation of law, that's most municipal attorneys' interpretation of the statute. Other municipal attorneys have gone a little bit further and said, well, it says you have to do this, but it doesn't say we can't also do this, right? So that's the argument right now. And I think we'll see, there's been so many municipalities that have been fighting projects and not allowing them that, I don't know what's gonna happen, with the law itself or how the MPSC implements it.
If I may, Mr. Chair, just one question, ma'am. One of the biggest issues for our natural environment, the impact, this current solar farm in Grant Township is actually, part of it is in the Lakes and Stream District. And the concern naturally for the locals is the impact on that. Does the state restrict these projects from being in certain districts, mainly lakes and streams?
No, not zoning districts per se, but it will do an analysis on impact on natural resources, okay? What is the extent of that analysis? How do they quantify it? How is it, who provides the information? How do they review it? I can't answer any of that, but they will, as part of their review, consider the impacts on natural resources. So this is why, as you can see, going to the MPSC requires a lot more frontline work up front of analysis and be able to justify your project at the MPSC versus either a CREO or even a workable ordinance, which may not be as restrictive. So those are the policy decisions that will ultimately come to this board after the Planning Commission does their work as to which approach you think is the most appropriate.
And one follow-up question, if I may, Mr. Chair. So the current solar project, part of it is in lakes and streams, as I stated. With this current case, or the cases that are before the state, could it stop it? Stop the current project if it's in lakes and streams?
Well, so I have to be very careful because we're in pending litigation on this case right now, so I need to be careful. But should somehow the permit that has been approved by the Planning Commission be reversed by the judge, all right? And just so you know, we had a court hearing yesterday. That appeal will be argued on March 26th. So March 26th, I think it's 1 p.m. is the date that question will be argued in front of Judge Gothier. Should he reverse the approval by the Township Planning Commission and there is no permit, all right? Then, of course, the solar company has its options to figure out what they're gonna do. Do they just go to the state of Michigan